Well, on this Tuesday morning, a pleasure to welcome Daniel Shea to our studios. Good morning to you, sir.
Morning, Phil.
Nice to have you here, and certainly timely, given my many years. And I have a lot of friends who have gone through divorce. And while the warring partners, if you will, the husband, the wife, the man, the woman, conduct their battle and their war, there's a whole lot of other people that are paying an unbelievable price along the way. Yes, it's the kids, but then it's grandparents and so on.
Yeah, and in many cases, the kid is confused, is upset about what's going on with their parents, and the grandparents or the extended family are often the rock and the steadying influence in the child's life at that point.
And I have to tell you, I've seen it. I haven't lived it. I've been fortunate that my own divorce and separation and all the rest of it went well, and we've co-parented very successfully for many years. But at the time, I've seen other friends where the battle has gotten just into the trenches, down dirty and ugly. The kids are very aware of the level of anger, animosity that exists. Even though one parent has left the house, the other parent is always agitating to the children. You know your dad, you know your mom. And so suddenly it's the grandmother and grandfathers that are the calming influence that the children most need, but that's when the viciousness kicks in.
Well, it can. I mean, and parents, have an obligation to their kids, and in the law that they're not supposed to speak ill of the other parent. I mean, that's a fundamental tenet. It's called parental alienation, and it's really not on.
What is it called?
Parental alienation.
Oh, okay, all right.
But it does.
It's a weapon of war in the minds of many people.
It is. It's not supposed to be going on. Sometimes it does, but you do get those situations where the kids are, caught up in the middle of some strife. Maybe not an alienation scenario, but certainly, animosity between the parents. And at that point, oftentimes they're looking to the grandparents, and the grandparents are hoping to become involved, or aunts and uncles and whoever else wants to have some time with the child to help them through the situation.
Right.
And just to maintain that relationship.
But at the same time, the two warring parents, lose sight, I think, of what makes sense. And it becomes, we're in this for points.
Well,
we're in this to extract. We're in this to cause pain.
They can be, and in that scenario, you often get the situation where people have to go to court, have to seek legal help in order to get what they call contact with the child under the new Family Law Act.
Right.
And so people tend to think of family law kind of still in the stereotypical kind of Kramer versus Kramer terms. It's the two warring parents and the kid caught in the middle. But, family law has changed. Families have changed. Up until 2011, we had the Family Relations Act, which dealt mostly with parents, spouses, and children. Those were the three kind of defined terms in the act. And we've got the Divorce Act, which deals with spouses and children of the marriage. And now we have in BC the Family Law Act, which doesn't just deal with those parties, but has a concept of something called a family member. And that family member can be broadly defined. I mean, it can include spouses, it can include parents, it can include children, it can include, for instance...
Are aunts and uncles loaded into that mix?
Not necessarily.
No.
But it's a very broad definition, and it can include, for instance, the adult son of a former separated spouse of yours. If you have separated from someone who goes and gets remarried and has a child with that person technically under the act is a family member of yours. And there are rights and obligations that flow between family members. And, the more distant the relationship, obviously, the less legal ramifications there are to it. But, you can certainly do things with respect to family members under the Family Law Act that you didn't used to be able to do under the old legislation.
And is all of this sort of written in stone, carved in stone? Does it exist as a statute, a clause, a subclause, paragraph 73, subsection 22250?
I believe it's 37 sub A sub 1. Don't quote me on that. I'll have to look it up. But yeah, it's black letter law, what we call it. It's set out in the legislation, and it's been enacted by the British Columbia government. And, the interesting thing is that this legislation only came into force in 2013. And there's always a sort of a settling period after law comes into force where the courts are dealing with the new legislation. Cases are working their way through the legal system to come before judges and get decisions made. And that's when we really find out, what the new legislation really means and how it gets put into action.
And how it will work.
Exactly.
How will lawyers interpret how, what kind of arguments will be made in front of the judge.
Well, it's the best laid plans of mice and men, right? You have this legislation. It's designed to achieve certain goals, one of which, and I'll talk about this a little bit more later perhaps, was helping spouses and children that need protection from family violence, helping them get a more quick and efficacious way of getting that protection. And so that's why we've come up with this new and expanded definition of family violence and family member. And that's resulted in something that we call a protection order that's available under the Family Law Act that wasn't formerly available.
Now, is a protection order effectively like a stone wall that is erected between the aggressive parent, for lack of a better way of typecasting them, and the mom and the kids, or the dad and the kids?
Pretty much, yeah. You can think of it as a restraining order. It's
okay.
Something that's...
All right, that's the word I was looking for.
But what the intent is for it to be not necessarily a stone wall, but at least to set out really specific boundaries for what is and what is not permitted. A protection order could say you can't send this person texts and emails. It could say you can't attend at their workplace. You cannot attend at their residence. And it's the scope of a protection order is very broad, depending on what kind of family violence has been proven to have happened in the past or is in danger of happening in the future. And that's the sort of conduct that the restraining order, the protection order, will address.
Does this also deal then, and I'm just going to create a scenario here. Divorce is imminent. The partners have separated. Right now, the mom, the wife, is living in the marital home with two children that are aged 11 and 13. Doesn't matter what their sex, but aged 11 and 13. The father effectively has removed himself from the marital home, but is having regular contact through Skype, through chat, through text with the kids. Can the wife, the woman, prevent that from taking place?
If there's no reason for it not to take place, then absolutely not. I mean, the fundamental principle that the new Family Law Act is based on, and the courts have used for centuries, it's called the parents patriae principle, which means the court acts in the best interest of the children.
Right.
The court has to see what's best for the children. That's its fundamental concern. And it's almost always the case that contact between parents and children is for the best. In the scenario you've talked about, if there's no concern that the father is alienating the children from the mom, if there's no concern that he's poisoning their minds, that he's abusing them psychologically or mentally through this type of contact, if he's just trying to be a good dad, I don't
trying to maintain contact because he's only allowed one visitation a week, kind of thing.
Yeah, I think it would be very unlikely that a court would make any kind of an order. There'd need to be some sort of evidence that shows how this is harming the children to have contact with their father.
All right.
Yeah. But if the dad was, sending really nasty texts to the children saying your mom is doing this and this and she's a bad person, if he was, phoning the mom 20 times a day and, threatening her or
stalking, harassing, whatever,
that sort of behavior is the kind of thing that a protection order would address.
All right.
And now the interesting thing about protection orders is that they apply between any family member as that's defined in the Act. So, the stepchild of your former spouse. Extended family. These people are family members under the Act, and protection orders can be granted against them. So if in your scenario, the dad is getting along fine with the mom, but the dad's brothers are not and are being nasty to her in some way, then she could seek a protection order under the Family Law Act against those people.
Right. Effectively preventing uncles or aunts from sort of worming their way into an already difficult family situation.
Yeah, and it's not the test in the Act is it has to be a family member who actually lives with the person. So if it's if you're two grown adults and your brother lives in a different city but he's sending that may not qualify under the Act as a family member. But people who live in the same household and are related would probably be family members and could be subject to protection orders.
All right. Conversation this morning with Daniel Shea from FH&P on our Tuesday morning Law Talk, talking about family law as it pertains to extended, in parentheses, individuals, not necessarily the parents of the kids, but other relationships that are involved between people. And grandparents would be number one on that list, plus other immediate family members. Need to take a break. When we come back, we'll continue the conversation. If you have questions, we'd love to take your calls at 250-862-2525. Certainly, it's an area of law that increasingly is becoming more important because more relationships than ever before are ending in divorce. Back in a moment with Daniel Shea. Here we are on this Tuesday morning, on our Tuesday morning Law Talk with Daniel Shea from FH&P Lawyers. Today's conversation I thought would probably be of interest to a number of you, whether you're parents, whether you're, in particular, given the age of the audience that listens to this radio station, grandparents. And what are the rights of a grandparent? What are the access rules? How much, is it on a clock? And what kind of orders are written within the legal agreements that protect grandparents and children and making sure or ensuring that they can see each other? Daniel Shea, this becomes a fascinating, and yet it's fascinating because of how it works, intriguing because of the multiple characteristics and the personalities of the people involved, and yet at the same time, in the same breath, saddening. That we need to use our courts to find some level of rational discussion and rules of engagement.
Well, my favorite kind of family files are always the ones that don't require court time. And there's a lot of parties that, they separate, they can't live together, but they both have the common goal, the same common interest of making sure that their kids are properly cared for. And those people are, frequently rationally work out their differences, and they come up with a separation agreement that works for both of them. And those things, that's obviously my favorite kind of a file to run. But we do have the courts for when people just can't come to agreements, and that's what they are there for.
Okay, going to challenge your brain as a lawyer. We've received an email. Good morning, Phil. I have 3 grandchildren, aged 14, 12, and 7. I have not seen them for over a year. My daughter will not allow me to speak to them on the phone or to see them. It's all, apparently, because she and I, according to her, do not have a warm, loving relationship ourselves. These children don't live more than an hour away from me, and I find it very hard not to be able to engage with my grandchildren or even see photos, as she has removed us from her Facebook. Do I have any rights at all?
The sad fact of it is, under the Family Law Act, grandparents don't have a right to access time necessarily. There's nothing in the Act that says a grandparent is a person who needs to have contact with the child. What there is there are provisions regarding contact time and who gets it. So the Act deals with a few different things. One is what's called parenting time, and only parents and guardians can have that. Grandparents aren't somebody who gets parenting time. But they can have contact if the court finds that it's in the best interests of the child that they do that. And the courts have very broad and wide discretion in the kind of factors that they consider in what's in the best interest of the child. So they will look at what the former relationship was between the child and the grandmother, who the important people are in the child's life, what kind of activities and functions they can attend with the grandparent. And
does history come to play there? Does a grandparent demonstrate or show the kinds of interaction that existed with the child prior to this estrangement?
Absolutely. Anybody can make an application for contact time. So that could be a grandparent, it could be an aunt or an uncle, an adult brother who's now estranged from the family. Anybody like that can make an application for contact time. Before they do that, people usually try and work out an agreement for contact time, because that can also be enforced by the courts. But where parties are estranged, like the grandmother in this case, and the adult mother of the granddaughter, oftentimes you can't come to an agreement, and that's where you have to go to the courts and prove what's in the best interest of the kid to have.
Where do the kids come to play here? Because as I look at this email, and I really appreciate the individual for sending it, we have 3 grandchildren here. Aged 14, 12, and 7. Mm-hmm. At some point, does the 14-year-old or the 12-year-old, maybe not the 7-year-old, but do the 14 and 12-year-old have an ability to say to their mother, no, excuse me, I want to see my grandmother and grandfather? Does the child have an ability to take action here?
Absolutely they do. Before it goes to court, the child can certainly tell the mom, look, I want to see grandma. If you're a 14-year-old kid, you've got, your own personality by that point. You've got some very strong likes and dislikes. And frequently, I tell my clients who are in this situation, if you keep the child from seeing the grandma, you are going to run into issues with your own grandchild. They
down the road for sure.
Absolutely. It's not going to look well in your relationship in the future. But people have strong opinions, and they don't always take legal advice, so they do what they feel they need to do. And in this case, if the 14-year-old is speaking up and the mom is not listening to the 14-year-old, there's not really much you can do to the mom other than try and make an application in court for parenting time. You can use all the moral suasion and force of argument you can, but ultimately, if she doesn't want to agree with your position, she won't.
Wow.
Yeah.
And so, but again, it's as if the parent, in this case the mom, becomes the firewall that sequesters the children behind it, mm-hmm. And effectively flips the bird to the grandmother and says, I don't care what you think. Well, there's nothing you can do.
That is the role of parents. Their job is to protect the child as they see best fit. And when we run into disagreements, that's the unfortunate case is you've got a grandma who sees things differently than the mom. And it's ultimately going up to be up to a court, if they have to make a determination about what's really in the child's best interests.
Based on the way that this email is written, is this a terribly expensive process to embark upon? It
can be. I mean, you're probably looking at thousands of dollars in legal fees. Anybody who goes to court has to be expecting at least, several $1,000 legal mm-hmm. bill. You can make these applications in provincial court. Many people do that, and they do it on a self-represented basis, which is kind of the great thing about the Family Law Act that we now have in place, is that the provincial court has all the jurisdiction under the Family Law Act of the Supreme Court. So it can make orders regarding, protection orders. It can make orders about parenting time. It can make orders about contact with children. And people can go to provincial court and act for themselves.
Okay, so final note on this then is that really the grandmother at this moment does not have any powers here, and she's going to have to bite a bullet ultimately if you read the way the email is written. I mean, let's face it, the mom has even stripped photos out of Facebook kind of thing, and is not even giving a visual connect here whatsoever. Yeah. Sounds quite vindictive and quite punitive as the email is written. So really, there is only one course of action, and that's to find a good lawyer who wants to take on the case.
Well, do it yourself in provincial court. Find a good lawyer who can take on the case, or wait a couple of years. And it sucks to have to tell people that, but, the children will become their own people with their own ability to make their own decisions in due time. And you can expect that if you're a good grandma, they're going to want to keep in touch with you.
So that age is what in British Columbia? Is it 16?
Well, even before then, the courts will give significant weight to the wants and needs of a child.
Based on their maturity?
Based on their maturity, yeah.
Right.
And you can get that evidence if you do want to go to court by getting a views of the child report. I don't think I've ever seen it done in a contact time case, but I certainly wouldn't rule out that it could be.
All right.
That might be an option. But ultimately, the kid will say, what, Mom, I want to see grandma. And, they're going to be old enough to make their own decisions.
Yeah. But, again, what type of relationship does a 14-year-old have with her mom such that she can say, Mom, I don't care what you say. I want to see grandma.
Yeah, and, when they're 14, it's difficult.
That takes a lot of courage of a 14-year-old.
Well, my 14 tells me all the time what he wants. He has no problem with that.
Children are different these days.
Well, they're more assertive now, I think.
And that's not a bad thing, is it?
Well, it can
especially when we're talking in this context.
When you're talking about my 14-year-old, it's a bad thing.
Anybody else's children but my own.
Yes, he's too assertive. Everyone else is fine.
Yeah, no kidding. We are... I'm laughing, but it sometimes I think it's all you can do in these kinds of situations. Yes, it's emotional. Yes, it's very serious. Yes, it's emotionally painful. and sometimes all you can do is laugh.
Well, in this grandma's situation, my heart does go out to her, and
mine too.
There is no really good solution in some of these cases. The Act is doing the best it can, I think, to allow people to make these kind of applications for contact time. But, ultimately there's a very painful personal situation that has to be dealt with here, and those are never fun to work through.
And it's going to take, I would guess, based again on the way the email is written, it's going to take a lot of courage on the part of the now 14-year-old and a 12-year-old to find that intestinal fortitude, that courage to challenge our mom, who right now is the only parent that probably exists in the household, because obviously, the father is somewhere else as well. One would assume, even though it doesn't say that in the email.
Yeah, and that's sort of the thing that's interesting about that email is it doesn't say where the father is.
Yeah.
And you see this in a lot of cases where the parents are estranged. One of the parties, the parent, for instance, the dad in this case, I presume, is not very active in the role of his children. If he was, he would have an order or an agreement for actual parenting time, and he could use that parenting time to take the kid to visit the grandma or do whatever he likes with it.
Right.
So
that's an interesting twist.
Typically when the grandparents are in a situation of wanting to get contact time, it's because there is a missing link in the relationship. There's the dad or the mom who's out of the picture, and it's their parent who's trying to step in and get some access with the children.
Daniel Shea is our guest in the studio from FH&P. Fascinating conversation that we're having this morning. We'd also take your calls at 250-862-2525, or as in this recent case that we've been discussing right now, done by email, phil@am1150.ca, phil@am1150.ca. Either way, Daniel Shea will take your questions, comments. We'll be back in a moment. Conversation with Daniel Shea, FH&P, family law. And as I said at the walk-in, in these days of divorce when over 50% of all relationships by whatever religion or civil service are constituted, 50% of most relationships in today's world end in divorce and in some way, shape, or form a legal separation between the parents and the children that are involved. Daniel, I have to ask you, as we're sitting here and having this conversation, how does someone who is who you are, I mean, you're a lawyer, and someone retains your services, how do you protect yourself, or how do you prevent yourself from not getting involved emotionally? Because it would strike me that you become a representative, the mouthpiece, the advocate, if you will, for a woman or a man. It doesn't really matter in this incredibly emotional process. How do you keep yourself out of it? Because to me, I'm always getting choked up on air, even in conversations that I have with people, where it's hard for me not to get emotionally involved in the story that I'm telling. How does a lawyer over 3 months not get emotionally involved?
Well, there's a couple things I always tell myself when I'm starting a file. One of those is when I get my client's story, it's their side of the story. There's always two sides to a story. And any lawyer who practices family law is well aware of that there's always going to be a different side of the story, and what you're hearing from your client is only one half of it. And as you work your way through a file, you'll become aware of the other side of the story, and you will still be a zealous advocate for your client, but you'll be aware of the other mitigating factors that are out there.
As the other lawyer and the other half of this schism, if you will, or this fight start to present their case, do sometimes you find yourself changing almost the optics with which you're viewing your own client?
No, you never change. I mean, I'm always my client's zealous advocate. I've got a duty to do that. But what it does is it makes you aware of the weaknesses and the limitations of your own client's case. And, my obligation as a lawyer, partly, I think, is to help my clients work their way through very troublesome family problems with a minimum of stress and legal expense. That's almost always the case by working things out by way of settlement rather than going to court. Court is, where you go when you can't reach an agreement, I always think. And in order to get them to that point, I need to take the other party's position seriously. I need to make my client aware of that and give them advice about how things will play out in court in the event that's necessary. So I have to take a very dispassionate view of it. I can't just say my client's right and they're wrong, and I'm so wrapped up in my client's case, I can't see any other point of view.
Mm-hmm.
That doesn't give my client the best legal service that I can give them. And frankly, it will cost them a lot more if I do it that way, and I'm cognizant of trying to keep my client's legal fees to a reasonable, minimum. When I'm so wrapped up in my client's case, I'm not giving them good legal advice. They could be running off to court for all kinds of applications that would cost them a fortune and might not ultimately be in their best interest.
And what about when you see the lawyer on the other side or sitting at the other table with the other half of this conversation? Again, you can't help but not watch what they're about, and either admire the way in which they're approaching this very emotional story, because it is a story. You either admire how they're approaching this story and you respect the opponent, if you will, or sometimes I'm sure you're looking with an entirely different set of optics.
It almost always happens that I view other counsel favorably. It's very rare that you get a file with a lawyer who's acting unreasonably on the other side. Everybody who's doing family law that I've had the pleasure of practicing on the other side of a file with has been almost always very professional, very knowledgeable, very wise, and giving their clients good advice.
Is that because generally children as opposed to property involved?
I tend to think it's just because there's a lot of good lawyers around.
Okay.
I like to think of myself as one of them, but there are many, many good family lawyers around in Kelowna, and people, it's generally a pleasure to work with them. And I don't just say that because I'm a lawyer.
And I get that. But at the same time, when we're talking about division of assets, or we're talking about who gets the four-door luxury car and who gets the luxury SUV, and how are we going to divide out the boat, and who's going to have to have access to the ski lodge up at Big White kind of thing. In one case, there you're talking about assets that were purchased over time because obviously both of the partners are very successful financially. But the human carnage is the other side of it, which is the incredible impact upon children.
Yeah, I mean, there are lawyers who practice family law that do not get involved in cases involving children, specifically because those are the most emotionally trying cases, I think. When you're talking about
seriously,
assets...
So lawyers say, listen, I don't handle these kinds of family law cases.
There are lawyers who don't like to deal with cases that have children involved.
Right.
They like to do separation agreements between spouses that don't have children, divorces where the parties don't have children, because all you're dealing with in those cases is financial figures. What kind of spousal support should be paid, if anything? How are they going to divide up the condo and the RSPs?
Yeah.
And those are all fungible assets. But kids are not. Kids make things messy. Kids have a lot of emotional attachments, and that becomes difficult for the parties. It makes it much more personal between them, and that's where you get the big animosity type of cases.
Yeah, and children become the unwitting pawn.
Yeah, I frankly really like dealing with those kind of cases because that, I think, lets me as a lawyer help people the most with their most personal, fundamental problems. And that's kind of why I do it. But, there's no question it can be emotionally taxing, and it's my job as a lawyer not to let it get too emotionally taxing on me so that I can make sane, rational, legal advice for my clients.
We should be having this conversation over dinner because every time you speak, I think of these other things. Do you ever find yourself in a case, and I'm not trying to hijack your program here,
no,
but
fine.
Do you ever find yourself in a case where you ultimately end up saying to your client, after having heard the argument from the other side, having listened to your, the lawyer representing the other side and presenting the other side of the story that we were talking about a moment ago, do you ever find yourself then saying to your client, listen, you're angry, you're hurt, you've come to me and you presented a scenario which, as we've gone down this road now, and I'm hearing the other side of this, you really need to consider altering your position? I mean, do you almost become an advocate for the other side?
I don't become an advocate for the other side, but what I like to think, first off, is that I can usually anticipate most of what the other side is going to say. Yeah. I can hear my client's side of the story. I can say, okay, we're getting a divorce. Here's what we're asking for. We're asking for this and this, and we want this about the children, and so forth. But law and dealing with legal issues is kind of a call and response sort of thing. Like, here's my ask. Here's your response. Here's my reasons for why I'm asking. Here's your reasons for why you're responding the way you do. And it's the process of sorting through that lets you come to some sort of either one person realizing, my position is the better position, or the parties agreeing to meet in the middle, or them not agreeing to meet at all and you ultimately going off to court.
But
there are certainly cases where, I've had clients come in wanting one thing, and I have gotten a response from the other side that fills me in on information that my own client wasn't aware of or didn't tell me in the first place. And it's at that point that you go back to your client and you say, look, this is probably unlikely to succeed. We should maybe approach this a different way. We should maybe look for a different kind of solution.
This is a very subjective question, but I receive emails every once in a while. I read every once in a while. And you get an impression that the law still somehow does not stand tall for the fathers in many cases. I'm seeing movements towards fathers' movements, if you will, where fathers really do feel that the court still seems to be prejudiced towards the mother, prejudiced towards the female in the case or whatever. And the fathers still feel like they're getting done. They're still viewed as a bank book, a paycheck that is readily accessed on a monthly basis, and the law seems to tilt, or the table seems to tilt in favor of the mother. Have I misspoken here?
Yeah, I don't know. I don't think you've misspoken. There's certainly that perception that is out there for some people, and there are these parents or fathers' rights groups that have sprung up, and these aren't a new thing. They've been going around for a few years. But the two
I guess I've just become more aware of them because they're getting better at
mobilizing and communicating.
Yeah, exactly. Whether it's texts and emails and whatever, they're definitely getting the word out there.
The two things I would say to that is most of the frustration I find from fathers who come into my office has to do with the parenting time they get with their child,
or lack of,
and the child support that they're required to pay. Child support is set out in the federal child support guidelines. It's the law in British Columbia, and what you have to pay in child support is strictly a function of what your income is and how many children you have. And that's it. You put those two figures into a program and it spits out a number and says that's what you pay. There's no legal dispute about it at all, and nor can there be because we've had disputes in the past.
It's formulaic.
Exactly. The goal is to make it as easy and as simple and straightforward to enforce as possible. So is it biased against fathers? Unless you want to take the position that the guidelines themselves are biased, then no, it's not biased against fathers.
Right.
The other thing.
Listen, I need to take a break. When we come back, final thoughts with Daniel Shea from FH&P on our regular Tuesday morning law talk. Fascinating conversation when Daniel suggested the subject line. I didn't think we'd get as far into this as we are. But if you've been down the road of divorce, if you've been on one side or the other, if you've advocated for parent, if you've been that parent, then this is clearly a conversation that will resonate with you. Back in a moment. Daniel Shea in the last couple of moments here on this Tuesday morning law talk from FH&P Talking Family Law. Daniel, before we go, thoughts, I guess.
Well, one of the things was you'd asked me how you managed to not become too emotionally entangled in your client's problems. And you told me I could say this word on air. So when I first got accepted to law school, a friend of mine had said, "Oh, congratulations, you're in asshole school now." And I think some people graduate with higher honors in being that than other people do.
Which some people are inclined to think of lawyers.
Yes.
Listen, very quickly, ask Dan why lawyers and judges still don't know how to deal with the scourge of mothers who systematically alienate a father from the child. This is a form of child abuse. I've done hours and hours and hours of research on this. I feel lawyers don't feel this is an actual problem. You got about 30 seconds here.
No, people take it very seriously. It's written right into the Family Law Act nowadays. The province recognizes it as a problem, and I think parties and courts also recognize it as a big problem. There are ways of dealing with it through the court system, and you may not agree with the decisions that come out all the time, but there are certainly very real legal problems dealing with it.
Yeah, and again, increasingly, it comes back to this whole thing that the courts seem to grant the power of the custody to the mother in many cases. Yeah. And she sometimes wields that power rather unconsciously.
Well, one of the things that courts are determined to do is try and maintain stability in the kid's life, and often that means keeping the status quo.
All right. Listen, if you'd like to know more, certainly be happy to talk with you. That is Daniel Shea from FH&P Lawyers, talking to the delicate issue of family law on this Tuesday. That's it for us. Mr. Shea, thank you for being here.
Thank you. It's a pleasure.
Truly, pleasure.